Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, CEO and Managing Partner. And I know many of you often are going through this, have been through it, considering it, and you have questions. Well, hopefully that's why you're here. We're here to give you some direction, some answers live as you submit your questions here. You're going to use the Q&A section. You can do that right now. We already have some questions submitted, and we'll be going through those this morning or this afternoon. So again, go ahead and submit those in the Q&A section. Give us just your first name. Give us a city and state so that we know where you are in terms of giving it to one of our panel of the attorneys that are joining us. And speaking of that, we're joined by two of the Cordell and Cordell attorneys, Cassandra up in Pennsylvania and Christian in Indiana. Welcome to both of you.
Thank you, Scott.
Good afternoon, Scott.
Great. Well, we're going to talk a lot today. We're going to go through these questions and get you some direction. Always keep in mind, as we mentioned at the top of every virtual town hall, that we can't give you legal advice. This is informational. We're not having an attorney-client relationship either. We're going to be very general. We want to give you direction. The best opportunity, the best place to get that legal advice is through an initial consultation, and you can schedule one with us. You can go to our website, CordellCordell.com. You can do that right from the website without even picking up the phone. You can search in an office near you because we have offices around the country, and then you can schedule that, see the dates and times that work for you best. You can do it in person. You can do it on the phone, or you can do it virtually just like this, and we'll get that advice to you one-on-one, more intimate setting where we can go through the facts and circumstances related to your case, what you're considering, and really give you some good direction and some good advice. It's just not the right place for it here. But either way, like we do in all of our virtual town halls, we want to give you the information, the education, and the direction to go and the questions to ask and the next step when you do have that consultation with an attorney, whether it's with us or with someone else. But when you do find one, make sure that they practice exclusively in family law. That's probably the key. As I always talk about, as you're picking a doctor, for oncology, if you have cancer, those are the things I think that matter most when you're thinking about the selection process of an attorney who practices exclusively in family law. If you have other questions after this and you think about them, you can submit those via email for the next time we do our town hall. And you can submit those to townhalls@cordelllaw.com. townhalls@cordelllaw.com. So we're going to get right to it. We're going to talk a little bit about a hot topic in family law before we get to your questions, but make sure to submit those in the Q&A section right now. As we get through this, we're going to stick to our schedule and end at 30 minutes. But before we do that, let's do a really quick break and we'll be right back.
Fathers play a critical role in a kid's life. That doesn't change for single fathers. Cordell and Cordell is dedicated to protecting that role because we are a champion for fathers' rights. Kids count on fathers. Fathers can count on us.
Welcome back. And as I said, continue to submit your questions in the Q&A section. We already have a number of those questions. We're going to get to those. So really, I want to start off the top for just about 5 minutes. I want to talk about a hot topic that I think is relevant to everyone that's either going through this, has gone through it, or considering a modification of their decree of divorce, and that is legal custody. What you may see in the news lately in a number of areas, but particularly lately dealing with transgender decisions, or as we were talking off camera, COVID. COVID really changed the way we think about legal custody. And Cassandra, you and I were talking off camera before we began about that very issue that you have and why legal custody is so imperative and not to be overlooked. I've said that for 30 years, and that legal custody, you have to be very careful in the way it's worded. You have to be very careful in the rights that are afforded and assigned to each person in the decree. And you've had some lately experience with that very issue, right?
Correct. Yeah, currently I have a case and I'm very much so enjoying it. It's my client has an 11-year-old transgender daughter where he is not opposed to the transgender. He just wants to make sure that all questions are answered by the doctors, that he is involved with the decision making, and that he is just overall that he is involved, which of course shared legal custody is imperative in that sense that without shared legal, if mother had sole legal custody, he would have no say in this matter. Thank goodness he does have shared legal, so we're in the process of going through that and ensuring that it's handled as of course respectfully, and he is given all his rights he's afforded to in being involved in that scenario.
Yeah, that legal custody part, and I'm going to ask you, Christian, but I've always said you have to be very careful on how it's worded. Opposing counsel will try to do this, the magic language of meet, confer, and absent agreement, mom or opposing party or spouse gets the final decision making. So how that goes down is, hey, Christian, I'm just letting you know, what do you think about this surgery coming up? And Christian, you say no. And she says, I don't care. We're going to do it anyway. I conferred with you. That's all I needed to do. I'm sure you had that same conversation with your clients. And I'm curious your thoughts on legal custody, Christian.
Certainly, Scott. And what you're describing is what we've sometimes seen incorporated in Indiana as attorneys like to call it joint legal plus. And what it is they have the responsibility to meet and confer, but then somebody has the tie-breaking decision. And it goes down exactly like you described. Mm-hmm. It's, hey, I'm going to do this. Do you agree? No, I don't agree. Well, I'm going to do it anyway because I have the veto authority. And it pretty much goes that way every time. So I strongly recommend against anything that looks like that, any structure like that, unless you're okay with simply not having the authority to make any decisions or to have any input. When I put together a joint legal custody agreement, I have a whole bunch of standard language in a form bank that I will incorporate and customize to fit the specific needs. If there are any particular issues, such as COVID vaccines or a child who's transgender or anything of that nature, we make sure that we build in something that addresses that. If they're on the same page, we want to memorialize that and note that we need some kind of agreement of the parties to deviate from that. Either way, what we want to build into that is some language that says if there's going to be an impasse, if there's a disagreement, nobody gets a veto authority. They have the option to take that to mediation. And if mediation is unable to resolve it, then they can take it to court.
Mm-hmm. I think that's so key. And like I said, I mentioned COVID, I think broadened the idea of legal custody. And now we're talking about the COVID shot and what it does, where, you see news reports, data suggesting that perhaps it's not something that should be done with young boys or even younger males. As in terms it may have side effects. Those are the types of decisions you want to be very specific in, perhaps. There's no all-inclusive in Missouri. We can be very detailed about how legal custody is to be done. We can break it down by issue, not just leaving it to the what we call major health, education, and welfare. Let's just be very specific. So, and that's why I wanted to talk a little bit about it today, just because it is a hot topic, whether you're talking about transgender surgery, whether you're talking about hormone therapy, whatever it may be, COVID shots, even in the event of another type of mandate where we're closing, what that is to do. You go to school, what choices, how are you making the decisions? So just be careful. It's a conversation you want to have with your attorney moving forward about how specific should we be, can we be, and what do we talk about and what do we do? And it's part of the negotiation as well. You don't want to overlook legal custody. All right. So let's get to the questions again. Submit your questions now in the Q&A section. We want to get to those. Let's just start off the top. Cassandra, I'm going to throw this first one to you. It's from Dennis. How long should it take to get a court date for equitable distribution of property after motions are filed? Now, I don't have the state, so basically just talking about property division. Maybe you can just talk from your experience up in Center Valley.
Correct. So in Pennsylvania, in terms of if you're talking about global resolution, not just a specific, like you want the house sold because no one can afford it, more specific issues, if you're talking grand scheme, complete total divorce resolution, typically within 4 to 6 weeks after a master being appointed, you have your initial conference with the master. And depending on, typically there's no need for any other appraisals or anything else needed to be done. But typically after that initial conference where the master confirms there's nothing needed to be done, you could have your final hearing roughly 4 to 6 weeks after that.
And I'm curious, Christian, what you're getting and experiencing in Indiana. Here in Missouri, COVID did slow everything down substantially, particularly in St. Louis County, where I am. There was a mandate that cases be resolved on average in 6 to 8 months, certainly no greater than 12. That has gone out the window. I can tell you I've had a case pending since probably mid-2021, and I'm trying to get a court date. And it's just, they're so backlogged. So the alternatives, what I'm telling my client is we get a special master or a judge to act as an arbitrator, a retired judge from family court, hear the case, in a few weeks and then make the decision to just be done. So that is an option we've been talking about since COVID began, was using retired judges, arbitrators, to really both parties agree that we're going to submit the evidence just like this is a trial. And whatever the ruling is the ruling we're going to live by. But Christian, what are you experiencing in Indiana, especially in Fort Wayne? What's the court's docket looking like in terms of timing?
Well, Scott, I would say that COVID did in fact impact dockets quite a bit, and the caseload seems to be larger than it ever has been here in Fort Wayne specifically. In surrounding counties, the caseload is still a little bit lighter. It's easier to get into court a little bit faster. But the key that kind of stretches out the timeline for a divorce is not simply how fast the court can get you on the docket. There are a lot of prerequisites that often get in the way. Sometimes it's like Cassandra mentioned, maybe you need an appraisal or something of that nature. Sometimes there's discovery involved that you can't really expedite. Appraisals, subpoenas to third parties, anything like that that's going to affect it. And it's very important that you not take shortcuts on those things, because it can make a very, very big difference to the final outcome. And if we have children involved as well, which weren't mentioned by the question, but if, for instance, we have a custody issue, we're going to be looking at mediation, which is going to be required here in Indiana before you can set a final hearing date on the issues, including equitable distribution. So you may be looking at a few months out just to get in front of a mediator. And arbitration's not really used much here. I haven't seen it done outside of instances where both parties are pro se. The court maintains an arbitration docket. But the fastest way is usually simply to exhaust all avenues for settlement and to engage fully in the mediation process. You may be surprised at what kind of outcome you might find. Mm-hmm. If that fails, then here in Fort Wayne, we're often looking about 4 months out from when you request that final hearing. In surrounding counties, more rural counties, sometimes you can get in front of a judge within 2 months.
Sounds good. All right, Christian, coming back to you. Dave is in New York. Dave says he's responsible for child support until age 21. The child is now 19, in college and out of state. The child is going to be studying abroad for a full semester. With the child being out of the country until he turns 21, is Dave still responsible for child support? And I have some thoughts on that as well. But Christian, what do you say?
Yes, Dave. I'm licensed in Indiana. I can tell you how Indiana does it. At 19, all children are emancipated unless there's a disability or something of that nature that's going to require them to be cared for a longer period of time. You can emancipate children more quickly in Indiana if they've reached the age of 18, they're not in post-secondary education, and they're supporting themselves. So what I would recommend is sitting down with a New York attorney from our firm and discussing whether New York statute has an option like that. Maybe if the child is spending a certain amount of time out of the home, there may be an option there. We do often see people who have children go off to college and they're still paying support. And it seems a little bit mind-boggling that you would do that. Yeah. Quite often you'll see a petition for college expenses that will sort of take the place of support, but support can still be ordered and can still be maintained even if the child's not living with the custodial parent full time, such as going to college or, yes, studying abroad.
Yeah. In Missouri, I can tell you what I've done historically, because here we pay child support until age 21, so long as they're continuing to pursue a degree and passing their courses. So if the child is either not returning during the summers, which oftentimes after a year or more, the child will just move and live permanently in the city in which they're going to school, or in this case, they're going out, going to be abroad, I've asked to do a number of things. To reallocate some of that existing child support to the child directly to use while they're away. Now, keeping in mind that I tell the judge, even a teenager or a 21-year-old won't necessarily wisely use the full amount of child support. So let's just only give a very small portion. Some portion can be used to give to the custodial parent to maintain the residence if the child has shown a history of returning during the summer, or just asking the court to suspend the child support payments until the child moves back to the marital or to the previous custodial parent's home. So depending upon New York, obviously, as Christian said, you would want to set a consultation with one of the attorneys up in New York. We have a number of them. You want to do that just to get some information on that. But there are options likely for you in any regard like that, especially when you're going like in Missouri up until age 21. All right, Cassandra, let's go from Maurice in Phoenix, actually. They signed an agreement where mother will take responsibility for the family vehicle. Father is responsible for his vehicle 30 days from the date the signed decree. Mother is reporting she cannot take on the family vehicle and its debt. The vehicle, that family vehicle, is signed solely in Maurice's name. Maurice can't afford two vehicles. What can he do?
Well, absolutely. If she can't afford it, it sounds like you would need to petition the court to potentially, I referenced earlier, things such as forcing the sale of the home, because no court across the country that I'm aware of is ever going to want anyone's credit impacted based upon the actions of the other. So if she now says she cannot afford it, I, at least in Pennsylvania, would recommend to my client that we petition the court to have that car be sold so that there is no longer any trade-in value, and she would need to secure other transportation, whatever means she might. But I would have the special relief petition prepared to force the sale of that car if she cannot afford it. And you have proof of the same, that she cannot afford it.
Right. Even the emails where she's indicated she can't take it on. You want to look for language in your decree or in that agreement that's hold harmless language typically. It says that mother assumes the responsibility of that debt and shall hold father harmless. Now, if you're going to jump the gun a bit, but I think Cassandra's suggestion is a good one, to just have it ordered sold. She indemnify you for any loss associated with it or any resulting debt if it's upside down, and the continued payments, late fees. So it could ultimately be something like a motion for contempt or motion to enforce if the case is still pending. You just have an interim agreement. There are a number of things you can do. Obviously, we have offices in Arizona. I want you to then consider having that consult, getting some direction, letting them look at that agreement to give you some ideas and some direction to protect your credit score, protect your finances, protect your interest, and to take action. But the last thing you want to do is really to wait. Time really is not on your side, and you want to act on your rights when something like this is happening. And the attorneys over in our Arizona offices will certainly give you the right guidance. So continue to submit those questions to Q&A. Let's continue on. Christian from Tom. I have a 401k that my soon-to-be ex-wife is not aware of. There's not much enough to pay down my debt and go towards there's not much in it, just enough to pay down debt and go towards lawyer fees. How is that viewed if I were to pull that money before divorce proceedings occur? Would there be trouble for me? So the key here is nothing's pending yet. And obviously, which would maybe trigger some existing orders. But how would that be problematic for Tom? Christian, what do you see?
Well, Tom, you want to be careful with that because you often see, judges see this every day, where someone is going to make a little maneuver and try to move some assets around, move some debts around in advance of a divorce, often with kind of nefarious intentions to hide something, to put themselves in a better position and their spouse at a disadvantage. So the risk that you bear there is, number one, that the court is going to view that as you pulling a sneaky maneuver, and you could face some kind of court sanctions for that. Even if there's not an order in place, they could still attribute those funds to you when it comes time to divide up the marital estate. The other issue you may run into outside of the courtroom is that if you withdraw that money from the 401k, you may be subject to tax withholdings or something else that's going to reduce the amount that you have available. And that's coming straight out of your pocket if the court then includes that in the marital estate. You're going to eat that tax burden at the end of the day. If they value it at the amount that was in the account, now that tax money just came out of your pocket and you're getting less value than you had in that account.
Yeah.
My recommendation is generally not going to be to touch that money unless it is an absolute necessity that you cannot avoid, and make sure you're consulting with an attorney before you take that step.
Yeah, absolutely. And not only that, I rarely recommend clients use their retirement to pay off their own debt, which technically could be marital debt anyway. So you're taking your asset, paying off a marital debt, where the court may hold that against you and then still not assign half that debt to her. I'm not a big fan of paying off debts until it's divided, so we know the allocation of that debt. Certainly, that may be your only recourse. You may be better off taking a loan against it to pay fees and then just living that way. You're not necessarily committing financial misconduct. It could be that that's all you have to do to help prosecute it. Again, it's one of those things where, depending upon your state, you're going to want to have that consultation with your lawyer. Take the right steps. Don't act too soon. Be calculated and be logical about it. All right. Cassandra, Hayden lives in Massachusetts. I'd like advice on how I'm to prepare for the future after my divorce, knowing what money I have available to live on versus what I will owe in alimony and so on. How can I plan where to live when I don't know what money I'll have for myself since the divorce isn't finalized yet? So really asking, hey, what kind of calculator is it? Support, child support? How much am I going to be paying in alimony? Really a financial analysis, I guess.
Of course. And I have many consults where people are debating whether or not to go through a divorce process based upon this information. Can I survive? What is my life going to look like should I make this decision? I can say in Pennsylvania, the general, now this is not including child support. Your question, Hayden, didn't mention child support, so I'll focus on alimony. That the general idea is that it's 30% of the difference in the incomes. If higher earner is 100,000, lesser is 60, we're looking at roughly 30% of 40,000 annually. Again, there are other factors that go into this, such as who's paying, at least in Pennsylvania, who's paying the mortgage on the marital home. There are things of this nature that can affect that as well. But absolutely, I would say talk to an attorney up near you, have a consultation because every state is different, and get a much clearer idea of what you might be looking like. But that is a general in Pennsylvania.
And, Hayden, one of the things we just wrapped up was a podcast series on what's called the economics of divorce. And that is more or less planning and understanding what are you going to be left with at the end of the day. And there's a calculator that we use. So I'd encourage you to watch that podcast. It's a multi-part series, and then we'll direct you to where that calculator is. And it helps you get a better understanding of how to plan. And on the last series we just dropped, we have an expert who's a financial analyst who talks about helping people like you, Hayden, getting ready to plan. What is it you're going to need? Understanding the effects of alimony now that it's not tax deductible with that change to the IRS code. Obviously, what you're paying now, you can't take a deduction. It is what it is. And so that's the best way to do it before you proceed, is to try to best plan it out, sit down with our lawyers up in our Massachusetts office, look through the calculators, the laws, what is likely to happen. Use that calculator we did with the economics of divorce. It'll help you with retirement, understanding how long you have to work, because you're going to wind up with less than what you started. That is an absolute given, no matter what. And that's something you need to consider. All right, Christian, BL asked this question. Is there a minimum amount of time that an appeal of a judgment is to be pursued? No kids, a divorce just filed just after reserve retirement was earned. COVID has cost him about 3 years of time in Maryland. So it's Bob, actually. So the question, I guess, is how long is it for an appeal? What's the guidelines in Indiana in terms of where you are? And we'll talk also to Cassandra about her appeals, and then certainly give Bob some direction.
Certainly, Bob. What you're looking at for an appeal is, first of all, you need a final order, or you need to have the court certify an interlocutory order, which means you need either the final order at the end of your divorce that resolves all the issues, or you need an order in the middle of it the court has certified for you to appeal, and then you need to appeal it within 30 days. So if you don't have a final order yet, you're not looking at an appeal. You need to get to that final resolution for your divorce before you're looking at an appeal. We have a great appellate team that can kind of talk you through some of your options there. But generally speaking, you need that final order before you can appeal. And there are usually some other options you have after that final order before you file an appeal, such as a motion to correct errors or a motion to reconsider, which are two options to either introduce new evidence or present the court with an argument that was not available or was not presented previously during your previous hearing. So you should explore all of those options before you go forward. If it's been more than 30 days since the final order was issued, there may still be some options depending on whether you've had some new evidence come forward or something else has come to light that was not available at that final hearing. You may be able to reopen your final divorce settlement.
Mm-hmm. Yeah, I think we have to be cautious about giving you some of the deadlines. There are very specific timeframes and things that must be done in every state in order to preserve rights for appeal. And we could throw the general days that you have to file, but I think we just be cautious because we don't really know what kind of judgment you have. Is it interim? Is it final? When was it done? There are fraud aspects, which gives you no time. Meaning if someone intentionally misled you, knowing that you would rely on it, that may give you a longer period of time. But I can tell you this, appeals, if you have an interest in appealing it, you don't mess around. You schedule an appointment this afternoon, because courts of appeal do not usually grant extensions if you miss it and you blow it. It's done. It's a very strict rule, absent you being in a coma or your attorney being in a coma, some medical emergency. So get online, schedule a consult, get that judgment in front of someone, let them tell you, hey, here's your rights to appeal. Then you can look at whether or not you should, what the options are to do that. All right, Cassandra, Frank is in Illinois. They have joint custody with 60-40 time to Frank. My ex has been audio recording me regularly. I found out when she came to pick up our daughter. In a heated argument, I saw something sticking out of her back pocket and a recorder fell out. She admitted she'd been recording me for over a year. I'm concerned that she has this incident recorded and has probably recorded many arguments in the past. She's planning a custody modification. Can these be used against him and affect him? Can she play them to a GAL in a custody battle? And generally, or is it legal to record someone? Every state's a little bit different in terms of whether it's, two-party, one-party consent, whatever that may be.
Correct. At least in Pennsylvania, we are a two-consent state. Whenever there's a reasonable expectation of privacy. So, Grit, my question to you is, where did this exchange occur? Was it in a crowded parking lot? Was it somewhere where you don't necessarily have a reasonable expectation of privacy? In terms of Pennsylvania, if you didn't, then that two consent is kind of out the window a little bit. But if it's at one of your homes and it's curbside, and it is a reasonable expectation of privacy, at least in Pennsylvania, no, that would not be warranted or allowed without your consent and knowledge of the same. That she should not be able to play that in court. In Pennsylvania, they would not. There could be ways that she could question you on, do you recall saying XYZ? And on the stand, make you replay it. And that would be something to talk to an attorney about proper testifying and being prepared for what she might say based upon this discussion and how best to put yourself forward in the best light, regardless of it being played or not.
And I think I've got this issue here in Missouri where it's a one-party consent. We just came to light in our case that's fairly new, that spouse has been recording the client repeatedly. So we're just going to ask for all the recordings. Let's listen to them, see what's there, see if it's of any value that could hurt us, and then decide otherwise. But obviously in a two-party consent state, or even worse, if recording devices were left in a place to be recorded, certainly then brings in federal wiretapping issues. Those are really things to talk about with an attorney as you consider defending against a custody modification as you believe is going to happen. All right, Christian, we're getting close. We have two more questions that are submitted. This is an anonymous. I have concerns that the mother may try to take our two kids to her home country in Russia, obviously currently hostile to the United States, and not return. This would leave me with little to no options. I'm much against her going there, especially given the current war condition. What are my options to prevent her from doing so? She's been asking me to update the children's expiring passports, which will require both parents. Am I being overly fearful here? Really, what do I do?
That's certainly a more unique situation that you're dealing with. And one of the things that I would want to ask you if I was in a consultation with you is how often the children travel overseas, outside of Russia. Do you take them on vacations abroad? Do you travel overseas with them at all? Or is it just strictly to visit home for their mom in Russia? So my curiosity would be whether or not their passports need renewed outside of mom potentially fleeing with them. If you're overly concerned about it, it may be something that's worth pursuing a preemptive modification of your custody order and considering whether you may want to get an order prohibiting her from traveling with children abroad. This is something that you'd want to handle preemptively. This is not something you want to sit and wait and hope that the worst doesn't happen, because it quickly becomes an international incident and it's beyond the authority of a family court to do much of anything about it. So it's an issue you want to stay ahead of.
Yeah. And, one of the things I know, you can go to travel.state.gov, and there is a way to flag passports, especially with children. It's not absolute. But if they use those passports and as they try to either enter a foreign country, it'll be flagged as not one parent doesn't consent to travel, especially if an airline swipes it. Go to travel.state.gov. It'll give you a little bit more information on what you can do. But I certainly agree that although it's not perfect, you may be preemptively trying to get an order that says no international travel, that the passports are to be held by you, that she won't have the ability to have those passports. Even though I noticed that you did travel occasionally internationally as a family, I think that's certainly, we have handled international custody disputes and issues. I know we've handled one with regards to Russia. And so it's worth a conversation again to just kind of plan, know your rights, but check out travel.state.gov. All right, last question we have submitted. We'll go to Cassandra. Mark says, judge is retired. What are the negatives of giving a new judge? And do judges really read all previous declarations in court recordings?
Well, that some judges all judges tend to do what they need to do, which yes, they have a duty to look at any and all pleadings previously filed within the docket. And whether that be transferred from one county to another, so new judge to another, but the judge will need to look at any and all pleadings associated with the docket. Will they necessarily read every single transcript? That they likely will not, but they'll look at all the pleadings to see the procedural history of what has occurred with this case.
Yeah.
And in terms of good or bad with your new judge versus your old, that is definitely very particular to, I would say, an attorney near you who knows those judges better to know. One judge may be more a stickler for procedure, which is good for you. Some may be more prone to speak with the kids at younger ages. There's definitely wide variations on how that could either benefit or hinder you depending on those specific judges.
Yeah. And I tend to think here in Missouri, obviously we have that. I've gone through 3 judges on a case, and it really is judge to judge. I think some of them will look at very, very briefly, how old is the case? What's been filed? Where are we? But they're not getting in the details. They're certainly not listening to audio recordings of, that's just my experience. I tend to think they're a little bit on the lazier side because they're too busy probably, but they just want to start over. Our hearings, what we call informal settlement conferences, are handled in chambers. They're very informal. The judge may take notes, many don't. I think they do that intentionally so they're not necessarily biased before a trial. They don't keep some of the things that may, because you're not going to be able to present all your evidence in these kind of opportunities, but it may be a good thing for you. As Cassandra said, for me, when I had some changes, it was a good thing. Things weren't going well with the judge. I didn't get a good feeling from the judge about how, if we were going to try this case. And so we're getting another bite at the apple. Does it set you back a bit in terms of timeliness? Absolutely. You never know what the docket's going to be like. But I don't put a lot of faith in this judge doing exactly what the other judge did, and that's good or bad for you. They all are independent. It's like having a whole different jury. If you were to impanel another jury, they're not going to look at what another previous jury did. They're just going to use their own independent judgment. So, it's an unfortunate thing when those things happen, or either retirement or administrative reassignment, but it happens. So, all right, that is all the time. And we like to try to stay right to our timing. We're a little bit over, but again, submit your questions. If we didn't get some of those and you have some still, submit those to town halls, that's plural, at cordelllaw.com. Or as I encourage many of you who asked questions today, go to cordellcordell.com. You can go ahead and search for an appointment without speaking to anyone. If you do want to call someone, the phone number is 866-DADS-LAW, 866-DADS-LAW, but you can schedule that consult right online, and any of our offices across the country. You can put in your zip code. It'll give you the options nearest you, the times available, how you want to do it, in person, on the phone, or virtual, whatever is easiest for you. Again, that's on the screen in the chat section, 866-DADS-LAW and cordellcordell.com. So we'll look forward to seeing you next month. And we've got answers for your questions. Check out that virtual town hall that I mentioned, that the economics of divorce. It was a multi-part series. I think you'll learn quite a bit. And you can use that calculator that we created that helps you plan a bit and understand the effects of a property division, what it means for you in retirement, what do you have to do with your job, how much longer would you have to work, what that may be. So until next time, have a great week.